that good? Want me to talk, or what? Talk, okay. Testing, 1, 2, 3. Hello. Maybe there's something more interesting to say than testing, 1, 2, 3. Tell me when you want me to stop yakking.
Good afternoon. This hearing will come to order. I want to welcome everyone, especially our good friends from the Subcommittee on Disability and Memorial Affairs, to today's hearing regarding VA's handling of disability claims for Persian Gulf War veterans. As a preliminary matter, I would like to ask unanimous consent that statements from 3 Gulf War veterans and advocates for the issues we will discuss today be entered into the record. The statements are found in each member's packet. Hearing no objection, so ordered. This hearing is the second part of the committee's 2-part series on the 25th anniversary of the Persian Gulf War, a war in which I served. Today we will examine VA's own data that reveals a 16% approval rate and an 84% denial rate for claims of Gulf War veterans for undiagnosed illnesses and chronic multi-symptom illnesses, both presumptive conditions under current law. VA often seems to deny these claims because it demands to know the specific cause for the illness. Yet under the law, presumptive conditions do not require causality because they are presumed to have been caused by service in the Gulf War. The critical point to understand is that veterans cannot receive VA care for symptoms of Gulf War illness unless the majority of those claims are denied by VA. We will also discuss former Undersecretary Allison Hickey's email citing her, quote, concern that changing the name from chronic multi-symptom illness to Gulf War illness might simply imply a causal link for veterans who served in the Gulf. Ms. Hickey's official email exposed VA's efforts to block not only the use of the term recommended by the Institute of Medicine for Gulf War illness, but also VA's practice of requiring causality for GWI claims, even though, again, presumptive conditions do not require causality. We also want to know more about an internal VA email, which has been provided to today's panel, that reveals claims evidence that has been lost even though VA system told veterans that such evidence was received. This is not particular to Gulf War veterans, but important regarding claims processing in general. I want to also mention that last Friday, March 11th, VA held a community of practice call to discuss issues related to our subcommittee's hearing held on February 23rd. The call included more than 50 participants, and it discussed how to improve care for veterans suffering from Gulf War illness. Unfortunately, the majority of the attention was given to a presentation by Dr. David Kearney regarding chronic pain, with what seemed to be an emphasis on PTSD and the use of mindfulness as a method of treatment for Gulf War illness. The call, coordinated by Dr. Stephen Hunt, shows that VA still clings to its often criticized efforts, and it contradicts his testimony from February 23rd, leading me to believe veterans suffering from Gulf War illness will never receive appropriate care, while Dr. Hunt is at all connected to the issue. While the conversation during Dr. Hunt's call warrants additional comments, I'll save that for a later time. Before I turn to my friend, Ranking Member Custer, I want to highlight that the invitation for this hearing specifically cited our interest in discussing, quote, veterans who served in the Persian Gulf War, unquote. And yet VA's testimony has lumped information from 1990 with the current OIF, OEF veterans in an apparent effort to reflect better statistics than those specific to our issue today. With that, I now yield to Ranking Member Custer for any opening remarks she may have.
Thank you very much, Chairman Kaufman and Chairman Abraham and Ranking Member Titus, who will be with us shortly, for holding this hearing on Gulf War veterans. As I have said during our hearing on Gulf War illness last month, in the 25 years since the end of the Gulf War, many veterans have suffered from symptoms that are not readily identifiable or well understood, and still struggle to receive compensation for their illness. During our hearing, the previous hearing, we heard from medical experts, researchers, and Undersecretary Clancy, and they all agreed that the symptoms of Gulf War illness vary and that research must continue so that we can better understand and treat our veterans suffering from unexplained medical conditions associated with their Gulf War deployment. In 1998, Congress passed the Persian Gulf War Veterans Act, which granted veterans who served in the Persian Gulf during the first Gulf War a presumption of service connection for their illnesses associated with their service. This gave our Gulf War veterans compensation for their illness and access to VA medical care to treat their symptoms. This change reflects our belief that veterans should not be denied disability compensation or access to VA health care because their symptoms may vary or because it's not fully understood what caused Gulf War illness or other unexplained symptoms. But 18 years later, we continue to receive reports that veterans suffering from Gulf War illness and other unexplained medical conditions are improperly denied VA compensation for not being able to establish a service connection when they were deployed to the Persian Gulf. Each time this happens, another veteran is being denied the compensation and health care that this nation owes to them, and this is simply unacceptable. We have also received reports that as a cohort, Gulf War veterans have a higher disability claim denial rate, higher than our OEF and OIF veterans. This is why I am concerned about the end of the Gulf War presumption of services connection this year. I'm concerned that veterans who may have been improperly denied compensation and health care by the VA will not have a chance to submit a claim after this point. I'm also concerned that veterans who became sick later in life due to their deployment will be unable to receive compensation or VA health care. The VA has extended this presumption period once, but now it's up to Congress to decide if another extension is necessary. I look forward to hearing from our witnesses today about whether another extension is warranted and necessary, and I also want to know what needs to be done to improve the disability claims process for Gulf War veterans. I want to know if Veterans Benefits Administration employees are properly trained to rate Gulf War veterans' claims, and how can we improve the quality of the claims rated so that veterans are not forced to appeal their claim every time. And with that, Chairman Kaufman, I yield back.
Thank you, Ranking Member Kuster. I ask that all members waive their opening remarks as per this committee's custom. Additionally, Chairman Abraham and Ranking Member Titus will provide their statements at the conclusion of the hearing. With that, I invite the first and only panel to the witness table. Thank you. On the panel, for the Department of Veterans Affairs, we have Mr. David Malinkin, Deputy Undersecretary for Disability Assistance. He is accompanied by Mr. Bradley Floor, Senior Advisor for the Compensation Service of the Veterans Benefits Administration. Also on the panel, we have Dr. Zachary Hearn, Deputy Director for Claims of the Veterans Affairs and Rehabilitation Division of the American Legion, Mr. Alexandra Morosky, Deputy Director for the National Legislative Service of the Veterans of Foreign Wars. Did I pronounce that right?
It's Alexander, sir.
Alexander, okay, I'm sorry. Mr. Rick Weidman, Executive Director for Policy and Government Affairs for the Vietnam Veterans of America, and Mr. Richard V. Spataro, Director of Training and Publications for the National Veterans Legal Services Program. I ask the witnesses to please stand and raise your right hand. You solemnly swear under penalty of perjury that the testimony you are about to provide is the truth, the whole truth, and nothing but the truth? Please be seated. And let the record reflect that all witnesses have answered in the affirmative. Mr. McClinican, you are now recognized for 5 minutes.
Chairman Kaufman, Chairman Abraham, Ranking Member Custer, and members of the subcommittees. Thank you for the opportunity to discuss VA's processing of claims for disability benefits from veterans who served and in some cases continue to serve in the Persian Gulf War. I'm accompanied today by Mr. Bradley Forrest, Senior Advisor in our Compensation Service. We will discuss our efforts to ensure that Gulf War veterans receive the benefits they have earned, VA's processing of these claims, its training and quality assurance efforts, presumptive service connection, the statutory authority for establishing presumptions, and the science and rationale behind such presumptions. This year marks the 25th anniversary of the start of the Gulf War. The initial conflict lasted from August 1990 until February 1991. However, neither the President nor the Congress has declared an end to the Gulf War. So men and women who served in the Southwest Asia Theater of Operations to this day remain entitled to presumptions of service connection based upon their service. As of the end of fiscal year 2015, almost 7.2 million veterans served during the Gulf War era, and over 1.8 million of these veterans were in receipt of disability compensation, which is the highest percentage of veterans in receipt of compensation from any era, wartime or peacetime. Gulf War veterans that receive VA compensation average greater than 6 service-connected disabilities, again, more than any other era. And Gulf War veterans now make up the majority of claims that VA receives. VA continues to improve the efficient, timely, and accurate processing of Gulf War veterans' claims. It has reduced its overall backlog of pending claims by approximately 86% from its peak in March 2013 to the end of February 2016. VA has also reduced the average days waiting for a decision to 93 days, which is a 189-day reduction from its peak in March 2013. The Veterans Benefits Administration is constantly looking for ways to improve the service it provides to this cohort of veterans. We closely review Gulf War issues with the Veterans Health Administration, the Department of Defense, the Institute of Medicine, and the National Gulf War Resource Center. VBA has a national quality review staff as well as quality reviewers in its local regional offices to ensure that employees correctly process and decide claims for Gulf War illness. Last year, VA conducted a special focused review of decisions on claims for Gulf War-related illness, which showed a 94% accuracy rate. Although the science and medical aspects of undiagnosed illnesses and multi-symptom illnesses are not yet fully understood, VA continues to review scientific and medical literature to gain a better understanding of the impact of these illnesses on Gulf War veterans. Presumptive service connection fills a critical gap when exposure to toxic substances or certain disabilities resulting therefrom are not specifically documented in a Gulf War veteran's service records. Service connection for an undiagnosed illness or multi-symptom illness requires service in the Persian Gulf after August 2nd, 1990, and a qualifying chronic disability that rises to a compensable level of severity before December 31st, 2016. Service connection is also warranted for veterans who contract certain infectious diseases, such as malaria, Q fever, and West Nile virus, after Gulf War service, and that includes Afghanistan. The Secretary of Veterans Affairs has broad authority under Section 501 of Title 38 United States Code to establish presumptions. To determine which diseases are associated with such service, the Secretary takes into account reports from the National Academy of Sciences and all other sound medical and scientific information that's available. Public Law 105-368 charges VA with the responsibility for notifying Congress of NAS findings that might impact presumptions of service connection for diseases associated with service in the Southwest Asia Theater of Operations during the Gulf War due to exposure to biological, chemical, or other toxic agents, environmental or wartime hazards, or preventive medicine or vaccines. That concludes my opening statement. We are happy to answer any questions that you might have. Thank you.
Mr. Hearn, you are now recognized for 5 minutes.
Thank you. 9,358 days. 9,358 days have lapsed since our nation deployed nearly 700,000 brave men and women of an all-volunteer military to soundly defeat an aggressor and secure the peace. Today, many of these veterans need our help, and sadly, they have not been able to receive the benefits associated with their service in Southwest Asia. Chairman Kaufman, Abraham, Ranking Members Custer, Titus, and distinguished members of the subcommittees on Oversight and Investigation and Disability Assistance and Memorial Affairs, on behalf of National Commander Dale Barnett and the over 2 million members of the American Legion, we welcome the opportunity to discuss the struggles that veterans with service in Southwest Asia have faced in receiving disability benefits associated with their Persian Gulf service. According to VA's March 2014 update for Gulf War veterans, 37% of veterans that served during Operation Desert Storm suffer from symptoms associated with Gulf War service. Yet, in over 9,100 days since the final shots of Operation Desert Storm were fired, approximately 80% of all claims associated with Persian Gulf service were denied, according to a separate VA report. The concept of the Department of Veterans Affairs presumptively service-connecting conditions associated with environmental exposures is not new to this generation of veterans. Veterans that participated in nuclear testing have conditions presumptively related to radiation exposure, and veterans with exposure to herbicides, such as Agent Orange, have a host of conditions that are presumptively related to their military service. So what separates the Gulf War generation from previous generations of veterans? For veterans with service in Vietnam, if they are diagnosed with conditions such as diabetes, ischemic heart disease, or a variety of cancers, outside of rare circumstances, they are presumptively service-connected for these conditions. It is simply a process of receiving a diagnosis and then determining the severity of the condition affecting the veteran. For veterans with service in Southwest Asia from August 2nd, 1990 to the present, gaining service connection for presumptive conditions is not as easily accomplished. Many of these conditions are symptoms associated with what VA has labeled as undiagnosed illness. The term is inherently gray and confusing. Veterans must endure years of medical testing and may even have multiple diagnoses associated with their symptoms. But here's the catch. The moment that the veteran is diagnosed, it is virtually impossible to receive service connection on a presumptive basis because the condition is no longer undiagnosed. The American Legion has over 3,000 accredited representatives located throughout the nation. To ensure we provide effective advocacy for veterans, we biannually hold Department Service Officer School. During last month's training, we specifically discussed concerns surrounding Gulf War veterans and presumptive service connection. Often, these representatives, state VA medical professionals, will assign symptoms to aging or, sadly, even malingering. For those that ultimately gain service connection, it only comes after years of testing to exhaust the possibilities of other diagnoses. This process often causes significant stress for veterans and their families. Beyond concerns surrounding VA, many veterans of our National Guard and Reserve components have an uphill fight regarding their medical records. While Operation Desert Storm serves as the first major conflict in the American century with an all-volunteer military, it also served as the impetus for frequent use of our Guard and Reserve forces. Unfortunately for Guard and Reserve veterans, treatment records become scattered between their duty station, mobility center, and forward hospitals. As a result, these veterans have conditions that could be attributed to their military service, but due to unavailable records are never able to receive the required positive nexus statement. To help correct problems facing Gulf War veterans, the American Legion believes that all of VA's disability benefits questionnaire should include asking if A, the veteran served in Southwest Asia, and B, has the medical professional considered the relationship between assault symptoms and conditions in Gulf War service. Additionally, we continue to call for a full implementation of the virtual lifetime electronic record. While VA has shown progress, concerns surrounding obtaining records from the Department of Defense continue to linger. Finally, there needs to be an increase in education for medical professionals regarding Gulf War veterans to decrease the delay in benefits, and an increase in outreach to veterans to improve their knowledge regarding presumptive conditions associated with Gulf War service. Again, on behalf of National Commander Dale Barnett and the millions of dedicated veterans that comprise the nation's largest veteran service organization, we thank you for having the opportunity to speak today. I'll be happy to answer any of the committee's questions. Thank you.
Thank you, Mr. Hearn. Mr. Morosky, you are now recognized for 5 minutes.
Chairman Kaufman and Abraham, ranking members Custer and Titus, and members of the subcommittee, on behalf of the men and women of the Veterans of Foreign Wars of the United States, I'd like to thank you for the opportunity to testify on VA's disability claims process with respect to Gulf War illness. Today's hearing is extraordinarily timely, as this year our nation recognizes the 25th anniversary of the Persian Gulf War. While symbolic recognition is important, the VFW strongly believes that the most meaningful way to honor the service of Persian Gulf veterans is to ensure they have access to the benefits they need and deserve. All too often, we find that this does not happen. This is largely due to the fact that the signature condition associated with the Persian Gulf War, commonly known as Gulf War illness, presents itself in a way that's not conducive to the traditional VA disability claims process. Consequently, our VFW service officers and appeals staff report that VA denies Gulf War illness claims at a consistently higher rate than other types of claims. Part of the challenge is that Gulf War illness is an inherently difficult condition to diagnose and treat. This is because it presents itself as a host of possible symptoms rather than a single condition that is clearly identifiable and unmistakable. What is certain is that more than 200,000 Persian Gulf War veterans suffer from symptoms that cannot be explained, such as chronic widespread pain, cognitive difficulties, unexplained fatigue, and gastrointestinal problems, just to name a few. Instead of Gulf War illness, VA uses the term medically unexplained chronic multi-symptom illness, or simply undiagnosed illness, to describe those symptoms. Although undiagnosed illness is considered a presumptive condition for Persian Gulf veterans, there are certain factors that prevent them from receiving favorable decisions when claiming that condition. When claiming undiagnosed illness, the veteran lists the symptoms he or she is experiencing. These symptoms are often seemingly unrelated to one another, affecting multiple body systems. As a result, VA assigns separate disability benefit questionnaires, or DBQs, for each symptom, and separate exams are scheduled. The current Gulf War DBQ asks the physician whether there is a condition of each body system present and then asks them to complete the relevant DBQs. Only after that are questions about undiagnosed illnesses asked. We find that this practice of assigning separate DBQs for each symptom being claimed in connection with undiagnosed illness has the effect of promoting diagnoses even when those diagnoses are minimally supported. Once a symptom receives a diagnosis, it's no longer considered connected with undiagnosed illness, which, as its name implies, requires that the illness be unexplained. Since undiagnosed illness is ruled out for that condition, the veteran no longer has the opportunity to be granted on a presumptive basis. Often lacking any evidence of the condition in the service treatment record, a nexus cannot be established and the claim is denied. VFW staff at the Board of Veterans' Appeals notes that remands become numerous in these cases, and veterans often receive several different diagnoses for the same symptom from different doctors as a result. They believe that this is due to minimal support for those diagnoses in the first place. It is apparent to them that VA seems to go to great lengths to find diagnoses for each symptom, simply so that undiagnosed illness can be ruled out. The practice of parsing out symptoms has the additional effect of preventing a holistic evaluation for undiagnosed illness. When the claim is for an undiagnosed illness, the VFW believes the physician should be asked more questions about the cluster of symptoms, which could be one illness leading to symptoms in multiple body symptoms rather than separate conditions related to each symptom. Only if there are confirmed diagnoses should separate DBQs be completed. To improve the current system, the Gulf War DBQ should be analyzed by a team of physicians, including those from a War-Related Illness and Injury Study Center. Additionally, VA should grant veterans reasonable doubt when deciding whether or not a veteran's symptoms should be considered undiagnosed illness. Mr. Chairman, we see this as the most significant barrier for veterans seeking service connection for Gulf War illness. As noted in my written statement, the VFW has several other recommendations, including analyzing whether it would be better to process Gulf War illness claims at a centralized location, better tracking for Gulf War-related BDD claims, enabling contract physicians to conduct Gulf War illness exams, and training for claims adjudicators. Mr. Chairman, this concludes my testimony. I'm happy to answer any questions you may have. Thank you.
Thank you, Mr. Morowski. Mr. Weidman, you are now recognized for 5 minutes.
Thank you, Mr. Chairman. No doubt each of you are asking yourselves the obvious question is, given that we're a single-generation organization, why are we here today? And the answer is we are committed. Our founding principle is never again shall one generation of American veterans abandon another, number one. But secondly, what is happening to the Gulf War veterans is all too reminiscent of the way in which we were bounced around on Agent Orange, where they denied, and most Vietnam veterans who've been through this, it's almost a truism that delay, deny until they die. And they're doing the same thing to those who fought in the Persian Gulf War. It is the sophistry involved in trying to break out the symptoms in multi-symptom Gulf War illness is, and then forcing you to prove that what that is connected to is, the reason why I say it's sophistry is VA well knows that you cannot pin down exact cause when you have a multi-toxin environment, which is exactly what you had during the Gulf War. And given that, together, it is something that what we should be doing is doing epidemiological studies intensively of this population compared with their peers in the military and the same MOS who did not deploy to the Gulf, and their civilian peers, because there may be something about military life in general. So it's, having attended the IOM meeting recently, I've, for the first time, really understand the emotional impact that they keep saying that there's nothing physically wrong with you. I mean, they'll beat around the bush on that, but basically that's what they're saying. And they keep running in. That panel, as an example, was half neuropsychologists and psychiatrists and half hard science. So and the chair was a psychologist. So it's little wonder that that panel recommended no more hard science, because that's too hard to figure out what has caused all of this, in order to, A, begin to come up with treatments that are effective, and B, protect our troops in the future by not exposing them in the same way to the same conditions. So, and in regard to those who are applying now, they play the game of divide and conquer on all this, and you're chasing a rabbit hole about what one particular symptom, what is the etiology of it, knowing full well that you can never pin that down. And that's the game that they put individual veterans in when they apply for benefits and file their claim for compensation. And that's not just for compensation, because you have to be service-connected unless you are almost indigent in order to have health care. So it is a denial of all of the rights of these folks. I was particularly shocked when I stumbled across this little puppy, and it's called VA DOD Clinical Practice Guideline, and it's from 2014. And in this, all of this is, the only thing missing in this bit of sophistry is a snake oil to wash it down, because it says nothing, produced at no doubt at great expense by VA and DOD, but doesn't do a darn thing to enlighten the individual clinician who is trying to help that particular veteran. I could perhaps say that more elegantly, but that's where it is. We worked very hard with Chairman Benishek and with Chairman Miller in bringing along the Toxic Exposure Research Act. And one of the reasons why we're so committed to that bill is not just for the children, but also understanding that any one of these toxic bills has to be multi-generational, that we've got to rationalize this process if, in fact, we're going to get beyond the Strum and Drang for every generation. We are going through it now on burn pits. There was a major article that came out today that VA and DOD are stopping any further research into the burn pits, and they are blaming the Congress for not appropriating more monies, and vice versa. Whatever the upshot is this: we need more research that is systematically, that is for real, into both toxicology and, even more importantly, the epidemiology of how these toxins manifest in the veterans population. I thank you for the opportunity, Mr. Chairman. I'd be happy to answer any questions.
Thank you, Mr. Weidman. Mr. Spataro, you are now recognized for 5 minutes.
Thank you, Mr. Chairman. Mr. Chairman, members of the subcommittees. I'm pleased to have the opportunity to testify on behalf of the National Veterans Legal Services Program. There are two topics I'll be discussing today: VA's handling of claims related to Gulf War illness, and the extension of the end date for the period during which a qualifying chronic disability must manifest in order to qualify for presumptive service connection. NVLSP has vast experience with veterans' claims for VA disability compensation under 38 U.S.C. Section 1117, which requires the VA to pay compensation to Persian Gulf War veterans for 1, undiagnosed illnesses, 2, medically unexplained chronic multi-symptom illnesses, and 3, diagnosed illnesses that the Secretary determines warrant a presumption of service connection. It has been over 2 decades since Section 1117 was added to Title 38 of the U.S. Code, yet VA adjudicators still have difficulty adjudicating claims for the first type of chronic disability in particular, undiagnosed illnesses. In our experience, there are 4 common types of errors that the VA commits when adjudicating these claims. The first type of error is VA failing to consider the favorable rules for presumptive service connection for an undiagnosed illness when the veteran does not explicitly claim benefits under that theory of service connection. This type of error typically occurs when the veteran claims entitlement to service connection for a particular diagnosis the veteran thinks he or she has, but does not refer to Gulf War illness. If the evidence ultimately shows that the veteran's chronic complaints cannot be attributed to a diagnosis, the VA adjudicator sometimes denies the claim due to the lack of a diagnosed disability, which is a requirement for establishing service connection under all other theories of entitlement. Although VA adjudicators have an affirmative duty to consider all reasonably raised theories of service connection, they often fail to consider the theory of service connection for an undiagnosed illness when that theory of entitlement is reasonably raised by the evidence. The second type of error is VA erroneously attributing symptoms that have not been associated with a diagnosed condition to a diagnosed condition unrelated to military service. VA then denies the claim on the basis that the veteran does not have an undiagnosed illness. We have seen several cases like this in which a careful review of the medical evidence shows that, contrary to the VA's finding, not all of the symptoms identified by the veteran are linked to a specific diagnosis. The third type of error is VA denying the claim due to the lack of medical nexus evidence. Under Section 1117, a Persian Gulf War veteran is entitled to the presumption of service connection for a chronic undiagnosed illness if certain requirements are met. In 2004, in Gutierrez v. Principi, one of NVLSP's cases, the CAVC emphasized that the medical evidence linking the disability to military service or the Persian Gulf War is not one of those requirements. The VA, however, continues to erroneously deny some claims for service connection for undiagnosed illnesses on the basis that no medical expert has linked the veteran's symptoms to Gulf War illness. The fourth type of error is VA denying the claim due to the absence of objective indications of a chronic disability without considering non-medical indicators capable of independent verification. One requirement for establishing service connection is that a veteran exhibit objective indications of a chronic disability. Objective indications include both signs in the medical sense of objective evidence perceptible to an examining physician and other non-medical indicators that are capable of independent verification. And that last part is the critical part. We've seen cases in which the VA erroneously denied the claim solely due to the lack of objective evidence perceptible to a VA physician without considering other non-medical indicators that are capable of independent verification. Now I'll move on to the second topic. Under Section 1117B, the Secretary must establish the period during which a qualifying chronic disability must manifest following service in Southwest Asia in order to qualify for presumptive service connection. After initially establishing a 2-year presumptive period, VA has repeatedly extended the end date. Most recently, in 2011, VA extended the end date to December 31st, 2016, due to scientific uncertainty regarding the time period in which Persian Gulf War veterans had an increased risk of suffering from chronic illnesses, as well as the fact that National Academy of Sciences reviews were still ongoing. Little has changed with respect to the level of scientific certainty regarding Gulf War illness. Due to this continued state of uncertainty, VA should again extend the date of presumptive service connection during which symptoms of a qualifying chronic disability must first manifest to at least December 31st, 2021, if not indefinitely. I'd be pleased to answer any questions you may have. Thank you.
Thank you, Mr. Spataro. The written statements of those who have just provided oral testimony will be entered into the hearing record, and we will now proceed to questioning. Mr. McClinican, based on testimony from many today, it's apparent that VA is not doing justice to presumptive claims related to undiagnosed illnesses and chronic multi-symptom illnesses. What good are your quality reviews when across the board VA isn't correctly applying the law?
Thank you for that question, Mr. Chairman. I'm not ever going to come to these committees and say that we are perfect in the work that we're doing. So I'm not going to tell you that. I will say that we've taken a lot of steps to improve how we process these claims, to include some of the suggestions that you've heard today, such as improved training, which we did just within this last fiscal year. Training is now a part of our challenge training that we provide to new adjudicators. All adjudicators were required to take revamped Gulf War training beginning in October of 2015, which is mandatory. I've heard the message about the DBQs. I intend to go back and look and see whether that's something we can improve on based on the suggestions that you've heard here today. But we have extensive quality review programs, both locally and nationally, where we do look at these claims, to include something that we did in addition to those two programs, which is to do the focused review that's discussed in my testimony. So we do have a very robust quality review program when we look at these processing of these claims. Having said that, I intend to look carefully at the testimony of the other witnesses and carefully consider their suggestions.
In 2015, the Board of Veterans' Appeals remanded about a fourth of these claims. Nearly a fourth were granted, only 6% were denied, and roughly half remained unresolved. These same percentages are similar to 2016 so far. This indicates a problem in the handling of these claims. We want to know what you are going to do to immediately fix these problems.
Mr. Chairman, I just want to challenge the idea that a remand means that VA did something wrong. In fact, due to the appeal process that we have, it's often because of the passage of time. Again, having said that, the goal is always to resolve the claim at the earliest point possible. And we've had some discussions recently about how we can do that better with the service organizations. If the board points out errors that make it back to the regional office, we try to incorporate that in our training to the best that we can.
Yeah, well, Mr. McClinican, will VA extend the presumptive claims deadline?
We have a rulemaking in progress that addresses that. Before I can provide you a definitive answer, we have to go through the rulemaking process. But I can tell you we got a new IOM report just recently, which the Veterans Health Administration is looking at very carefully.
Okay.
I agree with what was said here today that the science has not really changed recently.
Mr. McClinican, according to Ron Brown, president of the National Gulf War Resource Center, on August 17, 2015, VA stated it would, quote, do a statistically significant review of completed Gulf War claims to determine if there is a problem, unquote, in processing such claims. What is the result of that review?
I'll let Mr. Floor address that.
Mr. Floor.
Thank you, Mr. Chairman. We did do that review. It was approximately 360 claims. It was a statistically significant number. We found we had 2 claims which actually were improperly denied. We've taken action to fix those. And there were another 6 or a little more than 12 or so where we either had an examination that was not sufficient or an improper examination was done by VHA, and we're returning those to have those corrected. So our rate there was 94% accuracy.
Mr. Floor, can you provide that information to this committee immediately upon completion of this hearing?
Yes, we can do that, sir.
Very well. Ranking Member Custer. Now recognized for 5 minutes.
Thank you, Mr. Chairman. Well, it appears to me that this is deja vu all over again. We're revisiting where we were with the Vietnam veterans, and it was shortly after I came to Congress that Secretary Shinseki worked on this presumption about Agent Orange, and I think it hopefully has made a significant difference in the lives, certainly for veterans in my district in New Hampshire, and I really believe in following the science where it leads us, but sometimes we don't have it in a timely way. And so I appreciate you being with us, Mr. Weidman. And I want to focus in on that because it seems like we have a couple of different catch-22s that I'm trying to catch up with and follow here. One is that I am impressed by the data, and thank you for providing it for my district, about the reduction in the backlog on disability claims, the reduction in time that it takes for an average claim, and the improvement in accuracy of claims. But I'm trying to reconcile that with this data that the VA denies 80% of claims filed by Gulf War veterans for conditions related to the war. I mean, I meet veterans all the time that are trying to cope with this constellation of symptoms, and it's very challenging. And so I'm trying to determine, if we believe in this, if Congress passed this presumption, why are we having such a hard time addressing, and is the 80% denial, is that these are somehow malingerers that are coming forward? I don't meet those people.
So Mr. Floor has some of that more specific data that we can provide that to the committee as far as actual grants and denials, specifically for subsets of the Persian Gulf War period. I just want to point out, however, that to some extent, I assume that the 80% figure that we're talking about relates specifically to those Gulf War illness presumptions. In many cases, a veteran is service-connected for other disabilities that are diagnosed, and for that reason, there may be a denial on the basis of the Gulf War presumption.
I don't follow. I mean, if they're service-connected for something else, why would you deny?
Well, the condition may be diagnosable, is what I'm trying to say, rather than undiagnosed, and for that reason.
So I guess that's kind of the catch-22 that keeps coming up in the testimony of our witnesses, is we've defined this illness around chronic undiagnosed illness, but as soon as they get a diagnosis, then they don't qualify. That seems like really counterproductive to our goal, which is servicing these veterans who so bravely and courageously fought for us. So I guess let me cut to the chase. Do you need something different from Congress? And this leads to this extension, because I'm confused. You're talking about the VA. This is in statute. I mean, we need to introduce a bill, right? You need a statutory change to keep this going?
No, we don't. We have authority to establish a delimiting date for the presumption. The current delimiting date is that December 31st, 2016 date.
Which is going to be coming up on us pretty quickly. And what we learned from the situation with the schematic, is that how we just describe it? Heart disease? Ischemic, excuse me. That we didn't even know that, right? So I'm concerned there may be something that we don't even know. And particularly with toxins, I have a big problem, and this isn't on you, this is on us as Congress and on the DOD, about these burn pits and the toxins that are, and I think one of our witnesses said it best. I want to protect future troops. I want to know what's happening. So the science hasn't caught up with us. I'm very concerned about a fixed date of December 31st, 2016. And I just want to make sure that if you don't get it done, that we get it done here, because we don't even know the constellation of illnesses that are out there, and we want to serve our vets.
We will have the regulation done. The last time that we extended the delimiting date, we did it by an interim final rulemaking, which allowed us to put it out as a final rule. And then
in a timely way.
Yes.
So that people aren't stressing out over it.
And we intend to do the same thing in this case.
Yeah. And I do want to acknowledge the improvement that's being made, and you know, we want to work with you to make sure that we are serving our veterans. So thank you for your testimony, and thank you for the rest of you. I yield back.
Thank you very much, Ranking Member Custer. I will now question the panel. Mr. Morosky, in your written testimony, you note that part of the challenge with these claims is that the Gulf War illness is an inherently difficult condition to diagnose and treat because it presents itself as a host of possible symptoms common to many veterans that served in the Persian Gulf region. As a doctor, I can understand that VA examiners are more familiar with evaluating a single condition that is clearly identifiable and unmistakable. But that being said, how do you suggest that the VA improve the quality of the examinations of veterans who served in the Gulf War?
Thank you, Mr. Chairman. So, as it's been pointed out, it's a bit of a catch-22 for veterans who are claiming the undiagnosed illness because it could be a host of symptoms that they're claiming. It could be chronic pain, chronic fatigue, gastrointestinal problems. And these are all known symptoms that could be considered under the chronic multi-symptom undiagnosed illness. However, when VA looks at the claim, instead of giving one disability questionnaire to one physician who's claimed to look for these sort of symptoms and look at and consider whether or not those are Gulf War illnesses, they're parsed out, and one DBQ goes to a physician to look at the gastrointestinal problem. Another physician gets the questionnaire to look at the fatigue. Another physician gets the questionnaire to look at the chronic pain. And then, of course, when looking at them in a vacuum and not looking at it globally, what doctors do, as you point out, is to diagnose. So if the veteran comes back with diagnoses of Crohn's disease, fibromyalgia, and depression for those, they're no longer considered an undiagnosed disorder, and therefore they can't be considered undiagnosed illness, and so they're not able to be adjudicated on a presumptive basis. Whereas if they were considered undiagnosed, they would have been adjudicated on a presumptive basis. So since they're not individually these diagnoses, the claims adjudicators look into the service record and they don't see these there, and so they're denied.
So how do you suggest fix a different DBQ?
Yeah, sir, we would suggest a DBQ where when symptoms are claimed by a Persian Gulf War veteran that are consistent when taken together with Gulf War illness, that a single Gulf War illness DBQ be given to a single physician who's trained to look for these symptoms and look at them globally, look at them holistically, so that the physician can then say, yes, this is consistent with Gulf War illness, this veteran has an event which is service during the Persian Gulf, and then be able to grant on a presumptive basis in that way. So a holistic view versus parsing out the symptoms and looking at them individually.
Any other VSOs wish to comment, Mr. Hearn, Mr. Weidman? Any suggestions as how these examinations could be more productive?
Cannot separate the environment in which they were initially had the problem originate is you're never going to pin down what that silver bullet is. It just doesn't exist in environmental health science. And VA knows that, and that's why it's pulling it apart in order to come up with the wrong answer. The real question is, why haven't they done the epidemiological work on this population in a serious way that would give us some of the answers as comparing those who served in the Gulf versus those with the same MOS who served elsewhere during that time frame? And they haven't done that in any kind of serious way. And once they do that, then a lot of this will become clearer. Let me also just add that this VA has the authority to have a shutoff date. They did the same thing on lung cancer having to do with Agent Orange. And we finally took them to court, and they had to lift that delimiting date because they had zero scientific evidence.
And let me interrupt you. I apologize. I want your thing on, but I want to have time for one more question to Mr. Floor. Given what you've just heard, Mr. Floor, how is the VBA ensuring that the quality controls are sufficient to ensure the raters are held accountable if they rely on inadequate examination results for Gulf War veterans?
Yes, thank you for your question. As recently as the end of 2014, we actually revised our training materials for our claims processors with respect to Gulf War illness. We put it into our training system. Every one of our claims processors, including not only rating specialists, but the initial people that review claims, were required to complete that by last September, and they did so. So we've updated it. We're always looking at ways to update our training to make it better where we find that there are problems with it. By the same token, Veterans Health Administration revised their training for examiners who do Gulf War illness claims.
And what about quality in lieu of a purposes of a star for a rating review? What's going on there? Do you know?
Quality where? I'm sorry, where?
Star review.
Star review?
Yes.
Do we know about our star review quality? Our overall quality is like 92%.
Okay, and I'm out of time. I'll ask some follow-ups in a written questionnaire. As a follow-up, what about the 90 to 91 group? What's going on?
I don't think we have that quality by group. That's our overall quality rate.
Well, we would appreciate it for the record, please.
Okay.
Okay?
Take it.
All right. Yeah. Who's next? Mr. O'Rourke, you recognize, sir.
Thank you, Mr. Chairman. I wanted to ask Mr. McClennican to respond to Mr. Morosky's suggestion that you have one DBQ handled by a single physician to be able to look at this comprehensively instead of breaking it out into separately diagnosed symptoms.
Maybe it have been before you joined us, I'm not sure, but I committed to going back and taking a look at what we're using as far as a DBQ to see if there are those type of changes that we need to make. So I will go back and take a look at that.
Okay, so your commitment is to review it. You're not necessarily committing to that process, which seems to make a lot of common sense to me. If we're concerned about what the ranking member referred to as a catch-22, that as you begin to diagnose these individual symptoms, you no longer have an undiagnosed illness, that seems to be the answer to me. So I'm not sure, why don't you tell us the factors that you will look at as you consider the proposal? In other words, I'm wondering why you can't just commit to adopting that as the way forward.
Well, I'd like to show up here for a hearing and have all the information I need to answer that type of question, but I don't have all that information with me right now. The best I can offer you is that I will go back and look at that specific issue and the recommendation and see whether that's something that we can and should implement.
Yeah.
That's my commitment.
What's the argument against it?
Well, based on what I'm hearing, first we have to confirm that that is a real problem that veterans are experiencing, and if it is, then it's something we have to fix. So then I would not disagree that it is something we need to fix.
Okay, and I'm sorry to pursue you on this one, but it just seems as long as we have everyone here, we might as well get to as close to the bottom of it as we can. You said you want to substantiate the veterans are really having this problem of these separate diagnoses. It seems like every single person up here has confirmed that that's the case. I don't think that you doubt their credibility on this.
Not at all.
We don't, as the representatives of Gulf War veterans, doubt the stories we are told by our constituents. So that factor seems to have been eliminated. I'm very open to a counter argument to the one proposed by Mr. Morosky, but unless there is one, I think we've got to move forward. We can't, 25 years later, continue to extend deadlines or talk about this at another hearing. I've only been here a little over 3 years, and does not seem like we're making a lot of progress on it. Not because of any lack of commitment necessarily on your part, but I do think that we need to have a conclusion and a solution to this. And this doesn't solve everything, but I think gets to the catch-22 issue that so many of us have asked about and so many of the VSO representatives have highlighted. So all speed possible on your decision, and I, for one, I'm sure joined by the other members of the committee, would like to hear your response to that and would like to share it with the VSOs as soon as you have one. How long do you think it'll take for you to get an answer on that?
I'll start looking into it today when I get back.
Okay. And when do you think we can hear back from you?
I can't tell you exactly, but we're going to owe some information after this hearing as far as what we've taken for the record. I think we can make it part of that.
Mr. Hearn, question on a separate topic. Do you happen to know what the average age of a service member during the Gulf War was? 20, 21, 22?
In 1990, 91. I don't know that number off the top of my head, but
Early
think about
20s?
it like, I'm sorry?
Early 20s?
Yeah, I would certainly say early 20s, but let's think about it like this. If you do the math on it, a person that was towards the tail end of their career could have served in Vietnam. The son or daughter served in Iraq during the Desert Storm, Desert Shield. And then the children of those people from the Gulf War. So we're talking about 3 generations now, 3 generations of Americans. And I saw this, there was an article that came out in Fortune just this week. They said 25% of recruits today have parents that had served in the military. So it's very possible that this type of situation occurred, that we're talking about 3 generations of the same family could be impacted from serving in the same area.
Well, I wanted to ask you about a point Mr. Weidman brought up, which is how long it took for Vietnam-era veterans to have this presumptive condition awarded or recognized. And I wonder if someone who, let's say, was 20 years old in 1991 is 45 today, or if they were at the tail end of their career and they're in their mid-60s, if we're seeing different symptoms, in other words, cancers, as they get older, as this cohort ages, are we seeing more critical, urgent issues that need to be attended to? That the urgency that I think was part of eventually recognizing the presumptive condition for Vietnam-era veterans. I'm going to unfortunately have to take your answer for the record because I'm out of time, but I'm very interested in how we can add additional urgency as this cohort ages based on the conditions that we're seeing.
We'll be happy to look into it and send it to you then.
Thank you. I'll turn it back to the chair.
Thank you, Mr. O'Rourke. Dr. Benechek, you recognized.
Oh, thank you, Mr. Chairman. Welcome. Actually, I want to do a little more follow-up on what Mr. Weidman had to say. I think all of us here would like to know what's going on with this Gulf War syndrome a lot better. And, you know, a physician doesn't like a vague diagnosis. All right, you want to be able to do a blood test and then yes or no, right? We don't have that here. And I think the point that he made is that more research needs to be done is the critical one here. And do you all, are any of you all aware of what's going on in that department? Mr. Weidman, you mentioned specifically the epidemiology studies that you say haven't been done. What is going on in the research of this Gulf War syndrome?
The most useful research that's going on today is CDRMP, the congressionally directed medical research program. And the reason for that is that research and development at VA simply wasn't concentrating on research that would lead anywhere. And if, in fact, they committed monies at all. You know, it's real, if you decide you want to find nothing and you work really hard at it, the likelihood is you're going to find nothing. And that's exactly what VA has done here and in regard to other generations, both those who served in the recent wars as well as Vietnam. What Institute of Medicine has repeatedly, time and time and time again, is urged VA and DOD to start to mine the mountain ranges of data they have on all of us. But they don't do it. And that's how you could really start to make a difference. Let me just give you one example from Vietnam vets. Some of the most useful research that's been done was not directed from Washington, was not funded by Washington. It was individual clinicians in the field who, were able to hustle some graduate students and did epidemiological work of Vietnam veterans who had served in Vietnam or Vietnam veterans who had not served in Vietnam and who was more likely to have prostate cancer, as an example. That's how we found out that prostate cancer among those who served in country was almost 3 times that of the era vets. That kind of work is simply not being done by VA for any generation as a systematic thing.
I appreciate your answer, but I just want to get to a couple more items. Is there currently a registry for people that complain of Gulf War syndrome symptoms?
Yes, there currently is a registry program.
I don't understand, would you object personally to extending the dates of eligibility for this in view of the fact that there's, a lot of vagueness to the diagnosis here, and that more time needs to be, I think more research needs to be done, and to have this cutoff date be an issue for people when there's so much uncertainty as to what the real etiology is. I mean, it could be that there's some, bacteria like TB or something that has just not been found. That could be, really the answer here. And I don't know what it is, but there's a lot of uncertainty.
I have no personal objection. We have to go through the rulemaking process. But the reason why we did the 5-year delimiting dates was because of that uncertainty in the medicine and the science. So that still exists today. So if that reassures you.
Are there cutoff dates to is this a common thing that
Well,
VA does to cut off dates for application for
No,
eligibility?
the statute that we're dealing with here gives the secretary an authority to establish this particular cutoff date.
Does anyone else from the VSOs want to comment on what's going on? Mr. Morosky?
Sir, we absolutely agree that more research is warranted here. Right now, the only presumptive disorders for Gulf War illness are either certain infectious diseases, or you have this chronic multi-symptom unexplained medical illness. If under that, there are a lot of diagnoses, as I explained earlier, that come out of those symptoms. What we would like to see research is whether or not those diagnoses that are commonly given for those symptoms ought to be presumptive conditions in and of themselves. So if the gastrointestinal problems are being diagnosed as IBS, maybe IBS should also be a presumptive condition, which would lead to fewer denials, but that's what research would be for.
Mr. McClenchon seemed to indicate that a lot of the people were denied the undiagnosed disability, but were given a diagnosed disability. Is that the case? Or maybe I better take that for the record, since I'm obviously running over time. But if you could give me the percentage of those numbers for the record, I'd like to know that.
With respect to that, when the first Gulf War veterans returned from the Gulf and started complaining of multiple symptoms for which a diagnosis could not be established, VA had no way to compensate them, because our statutory authority is to provide compensation for disability resulting from injury or disease. So we worked with Congress, with congressional staff, and that resulted in the 1994 legislation that created Gulf War presumptions and the whole Gulf War process.
Mr. Fuller, we're going to interrupt you. The time is out, but if you'll put that for the written record, we'd appreciate that. Okay. Mr. Walsh.
Thank you, Mr. Chairman, and thank you all for being here. I'm going to go off this issue on the research and the cutoff dates. I think a little history is warranted here. Last summer, when the Agent Orange Act was coming to expire, 53 of us co-sponsored that, and it ended with a whimper without even a floor vote. And the argument we made is that the research wasn't in yet, and we need a little more time. That piece of legislation required the National Academy of Sciences to do meta-analysis of all the research that was being done out there and compile that. I asked last summer, at least extend it till March, till that study came out. Well, it came out last Thursday again with a whimper, and in that study, it showed a connection to bladder cancer and thyroid problems with Agent Orange. My question is, now, because that expired, and because there is no authority of that piece of legislation, do you have under Title 38 to do presumptions now for bladder cancer?
Yes, the Secretary has very broad authority under Section 501 of Title 38.
Is it naive of me to think that after 25 years of that and the biennial reviews by the National Academy of Sciences of meta-analysis of all the research that was out there, did we just do a wonderful job of picking the last two things they're going to find on the very last report that they will do? Would it have not made sense to extend it on for 5 more years to continue it? And I'm going to segue into this, that he has that broad authority. That broad authority then exists for Gulf War illness.
So for Gulf War illness, there's actually a Public Law 105-368 that was enacted in 1998. that requires both the NAS and the Secretary to report to the Congress on scientific study results that would impact presumptions for Gulf War veterans. That law still exists, and the Secretary still considers that information in creating presumptions. So
and I don't want you to speak for the Secretary on this, sir. I know your issue is where you're at and giving us the answers. What will it take now for Vietnam-era veterans with exposure to Agent Orange to get bladder cancer and thyroid issues, which are going to be multi-symptom, which aren't going to be difficult? What will it take now for them to get that covered and that presumption done? What are the next steps involved here?
So the Secretary is required to consider all medical science to include the National Academy's information that they provide. And based on the information that he considers, there's a work group that's established in the Department of Veterans Affairs whenever these presumptions are considered. It includes VHA experts, legal experts, our benefits experts, and they get together and prepare a recommendation for the Secretary.
And that's what happened with Parkinson's. We did. That same process went through for Parkinson's, and then the Niemer claims that came following that.
Yeah, whenever a presumption is created, it goes through this process. And if the science is there to support it, then the Secretary will create a presumption.
And I hearing you right that it's different for the Gulf War then than it is for Agent Orange?
Well, you had a concern about the expiration of the law that required us to go to NAS and then do a rulemaking within a specific period of time. That law expired for the Agent Orange presumptions. My message to you is really no impact for us because the Secretary has separate authority to do it on his own. And as far as Gulf War veterans, we're still required by law to receive those reports from NAS and consider them. So that gap does not exist for Gulf War veterans.
But I would suggest to my colleagues here, why were we so willing to give up to the executive branch the sole authority to make these decisions, and why we gave away our power at the expiration of the Agent Orange Act? Now it makes it very difficult for us to go back and make the case here so that we can have a say, so that witnesses can have their input into this in a more direct channel. And this is no condemnation on you. You're following the rules as they're written for you. This is a soliloquy maybe to us that I think we need to take more of the lead on this. We need to make sure, because I think as science moves along, the research possibilities are still out there, and I think we're shutting doors. And around here, once a door is shut, it is dang hard to get it back open again. And I think that is a mistake that we have laid the groundwork for, and this may give us the opportunity through the Toxic Wounds Act, Mr. Benishek and others, maybe is an opening to that. So I understand, and I know you'll do what is directed and want to care for the veterans. I think we need to give you the tools to do that. I think the broad tools the Secretary have is wonderful, and I cannot say enough when then Secretary Shinseki made the ischemic heart, the Parkinson's, it was the right thing to do. But that was a long fight, and now I feel like if you've got bladder cancer and you're listening to this, you've had thyroid issues where you were told it wasn't connected. As of Thursday, I'm going to say it was, and my suggestion is that I wish we as a Congress could say it was. So more of a clarification. I thank the chairman for your time.
Thank you, Mr. Waltz. Ms. Wolarski.
Thank you, Mr. Chairman. Mr. Spataro, I'm going to direct this question to you, but I want to tell you a quick story about a veteran in my district. She joined the Army in 1990 and was first deployed to the Gulf as a part of Desert Storm and eventually was deployed to Desert Storm. She eventually left the Army in 93, but after leaving the service, she began to have stomach pain, severe headaches, muscle pain, irritable bowel syndrome, and trouble sleeping. In order to cope with these issues, she took over-the-counter meds, not thinking those conditions were a result of her military service. Years passed before she realized all her medical issues were caused from her time serving in the Army. In 2011, she applied for benefits at the VA for Gulf War syndrome, but was denied about a year later. In 2014, 2 years after her initial denial and appeals the letters to the VA, she finally got an exam for Gulf War syndrome. After 3 years of battling VA, she received partial benefits for her migraines, irritable bowel syndrome, but not for the rest of her medical issues. Her issues have been so debilitating that she had to quit her job. In her letters, she says, quote, "Finally, on February 25th, 2015, I walked away from my job, my source of income, and the only source of reality that brought meaning to my life in the midst of pain and hurt besides my family." And this is, I'm going to quote her. Here's actually what she said to me in her letter. "I was more disappointed than surprised. After all, to the VA, we as veterans are nothing but a money business. We're numbers on a piece of paper with no face. The VA denies claims or takes forever to answer them, hoping we veterans will die before they come up with an answer. A VA representative advised me to write a letter to the VA telling them myself, hoping they would think of me as a person instead of a gold digger. And gold digger came from the person at the VA. Our veterans should not feel like gold diggers when they seek the help for the benefits they deserve. They shouldn't be treated just like another number on a piece of paper. And I wanted to tell you this story because it's what I hear from veterans almost every day. So my question, Mr. Spataro, to you is, in the case of this veteran from my district, many of her debilitating issues were denied by VA. Do you have an example of a case in which VA erroneously attributed symptoms of undiagnosed illness to a diagnosed disability? And you kind of alluded to this before, but can you kind of share a little bit more in reference to this case?
Yes, Congresswoman. It does seem like a fairly common problem that we see. An example where VA has attributed a symptom to an undiagnosed symptom to an illness. A case I had, for example, the veteran had liver problems. Blood testing showed issues with his liver, and the VA actually found that the veteran had hepatitis C. And we were flabbergasted. The veteran told me, "I don't have hepatitis C. Why is the VA saying I have hepatitis C?" We reviewed the record in the veteran's case, and we noticed that there was another veteran with the veteran's same name who had hepatitis C. His records had been erroneously associated with that veteran's claims file. And just carefully looking at it, you would have seen that the medical record numbers, the Social Security numbers were different, but that's a kind of error where there might be incorrect medical records associated with the claims file. Other times it just seems that the VA adjudicators are very quick to overbroadly interpret medical records and medical evidence without very carefully looking and separating each symptom and seeing if that a doctor has specifically attributed a diagnosis to each symptom.
Yeah, I appreciate it. And Mr. McClinican, did you recognize this issue? When you came to this hearing today, did you expect this hearing to be what you're hearing from members of Congress, and even in my case, a specific issue of veterans that we deal with every day? Or did you think it was going to be about something else? Were you aware of the fact that this was going to be specifically about all these quote-unquote undiagnosed diseases in this Gulf War syndrome?
Yes, that was the subject of the hearing.
So what do you do when you leave here and you hear all this information and testimony? We have questions, we have numbers, we have all kinds of unanswered questions. Many of us are, I think, left with this issue of how quickly can you correct this. Is there something that is correctable, or is this something that's going to take another action of Congress to fix?
Well, as I committed to Mr. O'Rourke, what I do is when I'm here and I hear these issues, I go back and look into it. And the DBQ is a good example. I wish, if that is the problem, I wish we could fix it overnight, but it requires coordination with VHA. We have to do the public notice that's required through Paperwork Reduction Act. But
do you think it's something that can be fixed, though, inside the VA without additional action from Congress?
yes.
Okay, I appreciate it. Thank you, Mr. Chairman. I yield back.
Thank you, Mr. Blickman. Dr. Rowe.
I wish Mr. O'Rourke was still here. I went to Dr. Google and found out that during the Persian Gulf that it was the oldest army we had since the Civil War, age 27, and 6 years older than the average Vietnam. And because a lot of reservists, I think, were called up, as opposed to when I was in the service, it was mostly drafted individuals. I'll start out by saying you cannot have too much information. That's impossible to have too much information. And I think you just extend the date at least 5 years, or maybe indefinitely, to study this issue. I would disagree with Mr. Weidman on one thing. Environmentally, you can specifically find, we may never in this case and probably won't, but you can find a environmental substance that is the cause of certain problems. There's no question. I've seen that over and over again. So the problem with this condition, and you've got 3 doctors up here, is headache, fatigue, chronic pain, and GI issues. I mean, we make our living seeing that, and people never got near the Persian Gulf. And it's really hard, and I think, Mr. Weidman, you've hit the nail on the head when you said we have to look. There may be a cohort of people in Iraq that you could study. There certainly are a cohort of people who never deployed, who were military age, who never deployed. And why we would stop investigating that is beyond me when we don't have a clear ideology of what this is. So I'm going to really strongly encourage the Secretary, if they have the discretion to do that, to extend this date, to get more information, because we want to get it right. I think everybody said up here, look, you've served the country and something that in your service caused you a disability, we need to compensate that disability. It's that simple. If it didn't, we don't. Right now, we don't have the information to say one way or the other, and to play semantics with words bothers me. Whether you call it Gulf War or whether you call it whatever, we're still talking about the same thing, and to presume somebody, to make a presumption based on how the verbiage is, it's silly, I think. It doesn't make sense to me. So I want to encourage us to do that. It is a very, very difficult thing to pinpoint. And I'm sure Dr. Abraham, Dr. Benishak too, will attest this. Two things that frustrated me the most in practice was we didn't know what was wrong with you. We just said you were nervous or you had a virus. So that when we didn't know what the problem was. And that's sort of what's happened to these veterans, I think. And I think we need to study it, make the presumption open-ended. I don't think we need to stop the end of this year. It makes no sense to me to do that. So until we get more information, that's really all I wanted, and I'm open to any comment that any of the panel members. It's been a great panel. Thank you for being here. You're welcome to comment, or I'll yield back my time.
Thank you, Congressman. As you pointed out, there are a group of disorders which can be common in the general public as well. I think the way we look at it is it's when taken together and put together with this event in service, which was service in the Persian Gulf War, and you start to see it over and over again as a cluster of symptoms, which is what we look at when we talk about Gulf War illness, as opposed to just parsing them out. And if you would use an example of, say, TBI, you see a lot of veterans, that's a signature of the current era war is TBI. You might have a veteran comes in and says, I'm experiencing some dizziness, I've got some memory loss, and I've got some sleep problems. If you looked at those individually, you might say, oh, you have vertigo, or, oh, you have some sort of a cognitive disorder. But when you look at them as a cluster, and then you look back in the record and you say, oh, you have some blast exposure.
That's a little different, though. You can specifically point to an etiology there where the veteran was within 50 meters of a blast or wherever. That's a lot easier than this one, than Gulf War illness is syndrome. It's much easier, I think.
I agree, but the comparison, I think, is there if you were to look at service in the Persian Gulf War, if we're going to assume, because there's already a presumptive basis for chronic multi-symptom disorder, if you were to look at that as an event in and of itself, but I agree with you that it's not a perfect comparison.
Here's what Mr. Weedman, and it's absolutely correct. Here's a blast, that's definitive, we know it happened and documented, no problem. There may be people that have those symptoms that look, I probably have had all those symptoms at one time or another in my life, and probably everybody at the dais out there has also had most of those symptoms. You could have those symptoms and be in Iraq and not have Gulf War syndrome. I mean, that's the problem that you get into, is that these are so common that it makes it's extremely difficult. Even more so than Agent Orange. This is much more difficult to nail down, I think, than Agent Orange is. Agent Orange, basically, I think we have the science, as Mr. Weedman clearly pointed, and Tim pointed out a minute ago, Mr. Walsh did. Here we don't have that, and that's why it is foolish to stop studying this. With that, I'll yield back.
Thank you, Dr. Rowe, and I'm going to start a second round of questions because I've got a question I want answered, and I'll start. Mr. McClanahan, you stated that one of the challenges faced by the VA is making the call as to whether a diagnosis is appropriate before granting an undiagnosed illness. However, under Joyner versus McDonald, it is inappropriate for VA to engage in this type of process of elimination. So why is the VA insisting that a diagnosis first be ruled out? I'm a little confused there.
Well, I guess the problem is we're talking about different types of claims. I mean, if VA gets a claim and an individual doesn't specifically claim that these Gulf War presumptions apply, and we're looking at the totality of the claim to grant what we can, it may be that that's what takes us down that direction of granting something that's diagnosed. Brad, do you have anything you want to add?
So why does the veteran have to specify Gulf War specifically? Again, I'm somewhat in the gray there. Because
If I may say, the problem with undiagnosed illnesses is that
well,
we,
so all theories of entitlement have to be considered. You understand that, right?
of course,
Okay.
yeah. But when we schedule someone for an examination who claims various symptoms which have not been diagnosed, the first thing doctors do, right, is try and figure out what the diagnosis is, because if they can't, they don't know how to treat it appropriately. So when they cannot come up with a diagnosis, then we're looking for the VHA or our contract examiners to say the veteran has an undiagnosed illness of the respiratory system, of the cardiovascular system, whatever it may be. But if they diagnose something, sinusitis, bronchial asthma, that becomes a disability, and then the standard rules of service connection apply. Has to be current disability, has to be something that happened in service, and has to be a relationship between service and the current disability.
When you start the exam, is that veteran flagged as a Gulf War veteran or no? Yes. When the exam starts, is he flagged as a Gulf War veteran?
Oh, no, when they file their claim, we have their service records, we have their DD-214, we know they're a Gulf War veteran.
But does the examiner know that?
They should, because I think so on the, when we schedule the exams, they have that information, yes.
Okay. So why wouldn't the examiner consider an undiagnosed illness in that case?
If the veteran is only complaining of constellation or several symptoms rather than the veteran claiming
Wouldn't
a
that be,
specific disease
by my
or
definition,
disability.
that is an undiagnosed illness if he's got a myriad of symptoms, but you can't put a diagnosis on it. Well, by definition, to me, that is an undiagnosed illness.
Correct. See, our claims processors are not physicians. They're not scientists. They can't make that diagnosis of an undiagnosed illness themselves. They need a physician to tell them that. They need a physician to say, this veteran has an undiagnosed illness. We can't do that ourselves.
So just really not quite sure how to handle the undiagnosed illness. Is that what you're saying?
I'm not saying we don't know how to handle it. It's a problem because generally they end up being diagnosed with a disability rather than an undiagnosed
illness. Is that
illness.
appropriate in all cases? I mean,
Not in all cases, but quite often that's what happens. We used to get, former Undersecretary Hickey used to get emails 10, 15, 20 a day from Gulf War vets saying, I don't know why I've been denied for my presumptive conditions. And they say, I've got sinusitis, I've got bronchial asthma. Those are not undiagnosed illnesses, those are diagnosed illnesses. And then they have to be associated somehow with their service rather than being a presumptive.
Ms. Turner, I'm just worried. What's your take on that answer? It's still, I'm somewhat...
Well, it's a little bit like the insurance commercials when there's Tarzan and Jane and they say, well, you know, swinging around the jungles, that's what they do. It's the same way with doctors to a certain extent because it's in your DNA, right? Make a diagnosis. That's what you do. Nobody wants to take their car to the mechanic and have the mechanic come back and say, I don't know what it is. It's the same way there. But the other problem is that what we have seen time and time again in doing our quality review checks is that there really ought to be a culture of when the rater looks at it, when the doctor looks at it, what can we do to get the benefit to the veteran? Not what does the veteran have? Those are two different thought processes. And a lot of times, there is nothing on the DBQ right now that says, is this veteran a Gulf War veteran? They go to the VBMS and it says, they would have to go all the way down, assuming that the VBMS isn't mislabeled, and look for the 214 to show that the veteran has, you know, the Iraqi Campaign Medal, the Kuwaiti Liberation Medal, the Expeditionary Medal. So there are all these parts that are going into this, and it's inherently gray, and that's what the problem is. And you know, I understand when they say that, and I guess I'm a little bit confused because VA had said that well, a lot of those remands, that was time constricted, or that was because of a lapsing of time. But remember, we're trying to get something service-connected here. So I don't know where the time lapse is going to cause the problem where you're going to end up getting remanded. Now, if it's an issue where we're trying to get an increased rating, then yeah, you've got dated exams, you've got other things that are going into play. So I think you've kind of got, you know, a mountain of things that are happening here. One is we need to train the doctors. It's not right that veterans are being told by doctors that they're malingering. That's not fair. And then you have to get them to get out of that DNA of diagnosing people, you know, and I think from there, if we can start tackling that issue, maybe we can start moving forward.
All right. Thank you, Ms. Turner. Ms. Custer?
I'm just wondering, just to continue this conversation, would it help if we changed the underlying presumption? Like, we've created this catch-22. As a matter of public policy, it sounds like it's an unintended consequence of what my colleagues before I got here were trying to do. We were trying to help Gulf War veterans who had a constellation of symptoms, and we didn't have the science and the words to catch up with what that should be called. And we've created, and we're putting the VA between a rock and a hard place. We've asked them, we've defined it as undiagnosed. And then I agree, when you have sinusitis or something else and you go to get the benefits based upon that, that's no longer undiagnosed. But the rest of the constellation, we still don't know the where or why or how. We know the wherefore, something to do with what was going on during that service. So I guess it seems to me maybe the short-term solution, and we've been talking up here about a bipartisan letter urging the Secretary to move toward this single DBQ, but we may need to also unravel the catch-22 that we've created in our attempt to help Gulf War veterans, because I agree with Mr. Hearn, our goal is to help them. But we've created these boxes where you start checking and it creates a problem. I want to get at, if we could, with either of our witnesses from the VA, the science behind this and what is helpful to you. Who do you rely on, and is the National Academy of Sciences or anyone else starting to look into what Mr. Weidman raised, which is, my concern is going forward. We are exposing our troops to toxic chemicals and waste that we do not understand the significance of. I've had a respiratory illness myself based upon a trip to Alaska during a volcano, okay? And my doctors had a hard time analyzing that and determining that. But I knew, I got on a plane, I was in a volcano, I was in the, I ingested that ash, which is crushed glass. It got in my lungs, and I was sick. Now I'm better. So who are we looking to? What is the state of the science, and what could we be doing to encourage more science to determine the causation on this?
Unfortunately, I think we're generally going to have to defer to the Veterans Health Administration. I know that you had Dr. Clancy here a couple weeks ago, and she provided some testimony on that specific issue, so we'll defer to her on that. However, Brad does have a close relationship with the National Gulf War Resource Center. He meets with them every 2 weeks, I believe, so he may be able to add some additional information.
Sure. Yeah, it'd be helpful to know what they're doing at this point.
Yes, we do work with them very clearly. We have bi-weekly calls and meet with Ron Brown and Jim Bunker in person quite often. Yeah. VA also has it's a statutory, I believe, Gulf War Research Advisory Committee that meets regularly. They recommend research, and VHA has an Office of Research and Development. They look at the recommendations. If they have funding to do the research that's being requested, they do that research. So it's not a matter that we're sitting around not doing anything.
I'm concerned about this decision of IOM to recommend not researching it, and it sounds as though the panel might have been skewed toward this is all in your head, which is not where we're coming from. So
I know there was a lot of concern about that.
Yeah, I think it may be something that we can look into in a bipartisan way of whatever needs to be done to keep this research moving forward. Because, again, deja vu all over again, what we went through with Agent Orange, there were symptoms and parts of illnesses and new illnesses that we didn't even know at the time. And I would have to believe that there's something like that going on here as well. So I'll yield back, but I'd love to work with my colleagues on the committee on that.
Agreed.
Thank you.
Ranking Member Custer. Chairman Kaufman.
Thank you, Mr. Chairman. Mr. Weidman, as a Vietnam veteran, you are probably familiar with the way Agent Orange claims were handled by VA. As I recall, presumptive conditions were frequently denied until VA was forced to resolve them under a NEMR lawsuit. Is that about right?
That is correct, sir.
Mr. McClanahan, does VA need to be sued in order for the department to properly address presumptive claims pertaining to the 25-year-old Persian Gulf War?
I would not encourage that. No, I don't think it's necessary. I think we're dealing with something, I think a point was made earlier, we're dealing with something a little bit different here. Agent Orange presumptive conditions are specific conditions, and yes, we've been operating under the consent decree from the Niemer Court for a long, long time. But here, as I think we've all recognized in this hearing, we're dealing with something that's much more difficult, which is the undiagnosed illness issue. Can we do better? I believe we always can, so we'll try to do that.
Mr. McClanahan, it seems to me that the 2004 Gutierrez case underscored this very issue, citing VA's quote-unquote clearly erroneous standard of review, and that the veteran was not required to produce evidence, quote-unquote, specifically linking his disability to the presumptive condition in his claim. Are you familiar with this case?
I don't recall that case specifically.
I am. So you're telling me that you, as a former general counsel, and the guy who's in charge of this entire issue are not familiar with this court decision. If that's the case, perhaps you're the wrong person for the job. Are you really not familiar with this court decision that's foundational to this issue?
I assure you I'll go back and refresh my recollection.
Okay.
And yes, I am the right person for the job.
Well, Mr. Chairman, I just want to thank you and thank the staff for holding this joint committee, and just want to say that as a Gulf War veteran, I'm just really disappointed that the law was passed, that by the Congress of the United States, that a specific set of conditions was supposed to be presumptive, and yet the VA does not seem to be following the law, and I'm disappointed, as well as the fact that I don't think the VA has made best effort in terms of research on this issue. Mr. Chairman, I yield back.
Thank you so much, Mr. Kaufman. Well, ladies and gentlemen, on behalf of the Oversight and Investigations and the Disability Assistance and Memorial Affairs Subcommittee, I thank you for your testimony. I appreciate all the witnesses coming here today to discuss what has turned out to be a very, very important issue. Unfortunately, the medical evidence indicates that some Gulf War veterans are developing serious illnesses such as brain cancer, multiple sclerosis, amyotrophic lateral sclerosis, and Parkinson's disease at relatively young ages. Moreover, the testimony we've heard today raises serious concerns about whether VA is accurately processing claims for veterans who are suffering from Gulf War illness, particularly those veterans who served during the first Gulf War. It is especially hard to understand why VA denies at least 80% of claims for undiagnosed illness and chronic multi-symptom illness conditions, even though there's a presumption of service connection for those veterans who served in the Southwest Asia Theater of Operations. I intend to continue to work with the department, my colleagues on both of these subcommittees, and the stakeholders who took their time to present these concerns today to ensure that veterans who are suffering from these serious diseases receive the benefits that they have earned. So again, thanks to everyone for being here with us today. As initially noted, the complete written statements of today's witnesses will be entered into the hearing record. I ask unanimous consent that all members have 5 legislative days to revise and extend their remarks and include extraneous material. Hearing no objection, so ordered. I thank the members and the witnesses for their attendance and participation today. This hearing is now adjourned.